To his credit, Dr. Diwakar is also on stage. Dr. Anand Vinaka, could you please come up on stage? Advocate Vaibhav. Okay. Advocate Vaibhav, we'd like you also on stage, please. Request you to take that. And Arlene. We'll start this evening session with a talk. Mr. Mohan's talk would be as soon as he comes, but we'll start with informed consent, not just a signature. And I think this is possibly the ultimate key and the most important component which a doctor has to make sure is in place. Thank you. Dr. Rajasekhar.
Used to taking informed consents, and nearly every surgery or most of the procedures these days are informed consent. But the question is whether our consent is complete, are we doing it the right way, or is there anything else that we can improve upon that. Common misconceptions about this are, if you give a paper and somebody signs it, so it's not going to become a complete consent. It's not just a signature, and many consent forms I have read, they use it as a disclaimer saying, the doctor can't be held responsible for so and so outcomes and things like that. It's not even a disclaimer. And if you have a consent form and getting it signed for the same procedure by everybody, again, one size fits all doesn't work. And many a times, most of the times in fact, the consent form is signed, given to them and signed on the day of the surgery. Then what is this informed consent? It's actually a process. It's not one paper, it's not one signature, it's actually a process. This is based on clear communication to the patient, and it should respect patient's autonomy and independence, and it must include, in an abbreviated form, the BRAN, the benefits, the risks, alternatives, and if the procedure is not done at all, then what are the consequences? Because patient has a right to refuse the procedure that we are advising, and hence he must know this. Then what about the timing? If the same day consent form is not acceptable, then what is the timing? It should be at least a few days, but not too long before. So it's a gray area here, but generally at least 2 to 3 days before the surgery, unless it's an emergency. That would allow sufficient time for the patient to think, read, understand, ask questions, clarify. And then these consent forms should be individual specific. It can't be a generalized form which is given just by writing the diagnosis. It should include what is specific to the patient, and if there are any additional risks in that given patient. It should be bilingual. India being a country with so many languages spoken, and it's nearly impossible to have all the languages printed or all the languages covered for the consent forms. It should have a regional language and one common language, that may be English, and it should be clearly understood by the patient. The language should be understood by the patient. If patient is not able to understand, then you should have a translator, and you should document the details of the translator. Video consent is also a possibility. So wherever there is a possibility of high-risk procedures or some patients showing unrealistic expectations, if you can make out from the discussions that you are having, and then if there is a language barrier, it's better to take an additional video consent. This won't replace the written consent, but this will add to the overall consenting process. Again, the video consent, there are certain best practices advised. While taking the video, you can ask as part of the initial part of the video that whether you can videograph the consent and you are going to explain the thing, and you confirm the language that you are speaking to in the consent, in the video consent, and then explain all these benefits, risks, alternatives, and not having the procedure, and ask for patient to repeat what he has understood if time permits and that's desirable. And you should record the patient's agreement, the patient's family's agreement, because in this video consent it's better to include some of the relatives also. And make sure that at the end you tell them that you are going to share a copy of this video with them, and also you are going to keep one for the hospital records. There are instances where courts have rejected a generalized standard format consent forms, and hence it has to be customized to the patient. Not necessary that you need to print the whole thing specifically for the patient, but if you have certain paragraphs left open where you can handwrite what is specific to the patient, what was specifically discussed, that also acts like a customized consent form. So valid consent is, it should be an informed one, it should be voluntary one, it should be well documented, and it is actually the entire process. In the OPD sheet, if you have explained certain things, make a note of that. If your counselors have explained during the process of counseling, let them make a note of that. And whatever consent forms or information that you have shared through email or through brochures, you document that, and again the signatures that you take from the patient. And it's a good practice to give a copy of the consent form to the patient. So consenting is not just a signature, it is actually a process, and in this process starts from the day you start advising about a procedure till the day surgery is done, and it should have all these elements in that where the patient is well educated about the benefits, risks, alternatives, and not getting the surgery done. So, and we have legal luminaries here. I also request Dr. Mohan and rest of them to comment on this, because it's one of the most important document in our clinical practice. Thank you.
Just confirm. I'll go to the next. You can talk next. Thank you, Dr. Rajasekhar. I have with me Dr. Karthik as well, who's just come on stage. I would now next call Dr. Diwakar to speak on documentation and record keeping, your best legal defense.
Excuse me, please put on the property. ಇದು ಕಳಿಸ್ತೀರಾ ಇದು? Good evening, everybody. Today, respected members, chairperson, moderators, and consultants on the dais. I thank viewers for giving me the opportunity to speak here today. My topic is documentation and record keeping, your best legal defense. Why documentation matters? Accurate documentation is crucial for patient's care. It helps in tracking the patient history and treatment. It is essential for legal defense in case of disputes and litigations. It demonstrates standard of care and adherence to protocols. Accurate documentation is crucial for patients care, helps in tracking the patient's history and treatment, essential for legal defense in case of disputes and litigations. Accurate OPD and surgical notes. OPD notes should include patient's history, examination findings, diagnosis, treatment plan, and follow-up instructions. And the IP surgical notes should include details of the procedure, findings, post-operative instructions. Accurate and timely documentation helps in ensuring continuity of patient care. Medical records in India are maintained in two primary formats. One is manual records, traditional paper-based files, discharge notes and referral notes. This method is still widely used in different parts of the India, such as there are some limitations like storage of space requirements and difficulty in retrieving the data. For the EH of the electronic health records, the digital versions of the patient medical history includes demographics, problems, medications, physical observations, science, history, and radiological reports, progress notes, etc. EHS streamline clinical workflow, support decision making, and quality management and outcomes reporting. OPD notes should include patient history, diagnosis, treatment plan, and follow-up instructions. Surgical notes should include details of the procedures and post-op instructions. Accurate and timely documentation helps in ensuring continuity of care. The duration of keeping medical records. Normally, so many doctors will be asking me how many days we have to keep the medical records. So duration varies depending on the type of record and the specific regulations. Inpatient records 3 years from the date of commencement of treatment as per the Medical Council of India guidelines. Outpatient records 2 years with some guidelines suggesting 5 years as per the DGHS, Directorate General of Health Services. Medico-legal records we have to keep it for 10 to 12 years until the final disposal of the case, especially if a complaint or a notice is received. X-ray, CT and MRI films for MLC patients are kept for 10 years. Expired medical records, the patient who expired, 3 years from the death of the patient, we have to keep that record. There are some regulations and guidelines. Some key regulations governing the medical record keeping in India are Medical Council of India Regulations in 2002. Mandates maintaining India records for 3 years and providing the records to patients or authorized representatives within 72 hours. Information Technology Act of 2000 addresses electronic record keeping and security. Clinical Establishments Act 2010 regulates clinical establishments and record keeping. NDHS, that is National Digital Health Mission Guidelines, aims to promote digital health records and standardized record keeping practices. EHR improves accessibility and visibility of the records, enhances patient safety and reduces errors, facilitates secure sharing of information with other healthcare providers. It ensures regular backups and data security. Signatures and timestamping authenticate the documentation. All documents, the IP and OP should be able to sign with the time and the date of the seeing the patient or reading the summaries like that. Ensures accountability and transparency. It helps in tracking patient changes and updates to records. It is essential for legal validity. Scanning of the reports can be done. It is more accurate. Ensure accurate and complete scanning of the reports. And verify and validate the scanned documents. Store the scanned documents securely and ensure accessibility. Regularly review and update the scanned reports. Accurate documentation demonstrates standard of care. It helps in establishing the facts and defending against allegations. Enhances credibility and reliability of the testimony. support defense against negligence claims. Here are some few examples of improper medical documentation of some practice that relate to medico-legal cases. Unrecorded preoperative evaluation before cataract surgery. A patient developed corneal decomposition post-cataract surgery and patient sued the surgeon. Issue the preoperative notes did not document corneal endothelial status or pre-existing fixed dystrophy. No specular microscopy report was filed. The court held the surgeon accountable due to the lack of documentation during adequate preoperative risk assessment. Second is an incomplete informed consent for intraocular lens choice. Patient received a monofocal IOL but patient expected spectacle independence. He claimed for the poor vision at near and he was sued for negligence. The consent form did not detail IOL types nor patient preference, no documentation or discussion regarding the options were taken and expectations were not recorded. Case favored the patient due to lack of evidence. The IOL type and implications were explained or consented to. Third is missing post-operative instructions after retinal surgery. After vitrectomy with gas injection, the patient flew on a plane a few days and suffered severe visual loss. The discharge summary lacked documented evidence to avoid following post-gas tamponade surgery. Surgeon found patient partially able due to the absence of documented post-operative instructions. Fourth case is no record of diabetic retinopathy screening in diabetic patient. A non-diabetic under the care of ophthalmologist for about more than 20 years suffers sudden loss of vision due to from proliferative diabetic retinopathy and vitreous hemorrhage. Ophthalmologist failed to document regular retinal exams or patient counseling. Even the patient was coming regularly to him, he has not documented the complications and the advisory treatment. The claims of medical negligence appealed as there was no proof of adherence to screening protocols. Undocumented patient non-compliance. A glaucoma patient lost vision despite prescribed treatment, promptly sued alleging in management. The records lacked notes on non-compliance, missing appointments, or lack of follow-up. Since the ophthalmologist could not prove the patient's non-adherence, on the burden of responsibility fell on the provider of the doctor. Illegible handwriting notes on an emergency eye injury. A patient presented with corneal foreign body and after removal he went into corneal ulceration and perforation, causing complete loss of vision. Handwritten notes were illegible, not with no clear record of antibiotic use, follow-up advice or warning signs. The court accepted patient's version due to lack of readable medical record and the clinician's defense field. So best practice to avoid all these things is always document baseline parameters, visual acuity, IOP, corneal opacity, corneal clarity, fundus examination. Record patient's education, instructions and consent clearly. Use standard consent forms and structured templates wherever possible. Note non-compliance and missed appointments diligently. Avoid ambiguous terms and issue legibility. Scan and store important investigations like OCT, fundus photos and specular microscopy. In summary, accurate documentation and record keeping are essential for the patient's care, legal defense and risk management. By following best practices and leveraging technology, healthcare providers can ensure high quality of documentation and reduce liability. Good documentation is not just a legal requirement, but a reflection of good patient care. Thank you.
Thank you, Dr. Thank you, Dr. Diwakar. We will now have the key and possibly the most important and possibly even the most dreadful component to a doctor, what the criminal negligence versus civil negligence, the thin line. Advocate Mohan will now speak on that. Maybe it's better you add this. Yeah. Otherwise, you won't sense. Please, you can't sense. You won't hear. I'll be hearing myself. So. This here.
Sorry, I'm late. I've never been late to a conference. Doctors have made me wait. I've never made doctors wait. Okay. Thank you, Dr. Reggie. Thank you, Dr. Rajasekhar. Thank you, Dr. Diwakar, and all the doctors here. And thank you, my brother colleagues. Okay, the topic that I've been assigned today is criminal negligence and civil negligence, the thin line. First of all, negligence is, I think all of you know about it, negligence is breach of duty. Actionable negligence is breach of duty that results in harm, and the essential components of ingredients of an actionable negligence will be duty, breach, and resultant harm. Now, having regards to the topic assigned to me, the first thing that occurs to one would be the case of Jacob Matthew versus State of Punjab, which is a very popular judgment, and all doctors should have read about it, or at least recommended that they read this judgment. It's available freely on Indian Qanun, or you Google it, you'll get it. Now, very interestingly, the task that has been assigned to me has been described in para 37.3, while the Jacob Matthew judgment refers to the Privy Council decision of 1943, and it reads thus: it is impossible to define culpable or criminal negligence, and it is not possible to make the distinction between actionable negligence and criminal negligence intelligible, except by means of illustrations drawn by actual judicial opinion. I think this is the reason that the panelists have asked me to assign this very topic to me. Yeah. Okay. Now, having regards to what the court has said, I totally agree with what the courts have said, and it is for this reason that I have collated all my experiences from the cases that I have dealt with and come about with this particular presentation. Now, in civil negligence, as you can see, civil negligence arises out of simple lack of care, precaution, and attention, also due to inadvertence. Civil liability is determined and assessed by the Karnataka Medical Council, where disciplinary proceedings for cancellation or withholding of license of the doctors are dealt with, and sections 35, 47, and 58 of the Consumer Protection Act, where money compensation is claimed. Then we have criminal negligence. The first thing that should come to a person's mind when anybody refers to criminal negligence would be the word rashness or recklessness, which forms the basis of criminal liability. What it basically in essence means is lack of regard for the consequences of one's action. If there is lack of regard for the consequences of one's action, it would come under the ambit of recklessness and therefore attract criminal liability. Now, criminal negligence, these would be the instances that I can quote for one's reference. Rashness and negligence of such a degree, knowing that hazard is most likely imminent. If the doctor knows that something wrong is bound to happen and he yet takes the risks, that is when criminal liability is attracted. Gross ignorance. The example that I can quote would be a doctor who would venture to give a certain dosage of injection not knowing or not bothering to find out what would be the correct dosage of injection to be administered. Gross inattention, a case where the paramedical staff is repeatedly asking the consultant to come and see the patient, but the consultant never goes to see the patient. All these are from my own experiences. Gross rashness would be a case where the doctor has gone ahead with the procedure with total disregard to the comorbidities the patient may be suffering. Gross deviation from standard of care would be using substandard equipment, substandard implants, etc. Finally, total disregard to patient safety. This reminds me of cases where there are not adequate instructions on advice during transfer of patient to a tertiary care institution. All these things have attracted criminal liability. The word gross has not been used in section 304A, which is now section 106(1) of the BNS, the new the penal code. The word gross has to be introduced and rash or negligent act is to be qualified by the word gross when it refers to medical professionals. This is what the Supreme Court has said in Jacob Matthews' case and also Dr. Suresh Gupta's case, which preceded Jacob Matthews' case. Criminal liability it is determined and assessed by the judges of the courts of magistrates or the sessions court. Section 304A, which is causing death due to negligence, is now section 601 of the BNS. 337, which refers to causing simple injury, is now section 125A of BNS. 338, which deals with grievous hurt, is now section 125B of BNS. Now, there was a lot of this is importance for doctors to note that there was a lot of information being circulated on WhatsApp groups that things have been made better with the new legislation, that is the new penal code, the BNS. However, these are things that that the doctors must note. Earlier, causing death due to negligence, the punishment was for 2 years or with fine or with both. But now it has been made 5 years and it shall also be liable to fine, in the sense that if found guilty, such persons will be imprisoned and also be liable to pay a fine. However, law has made a distinction for registered medical practitioners. Kindly note the word registered medical practitioners, because if you're not a registered medical practitioner and yet conduct a procedure, then you will fall under section 106, the preliminary part of section 106. So here the punishment has been retained to 2 years, but however, punishment and fine is what the legislation prepares, unlike before, where the doctor could have probably got away with just paying the fine. So things have become worse, not better. When can a doctor be booked for negligence under criminal law? Where there is a degree of negligence indicating a mental state described as total apathetic towards the patient, that is a total disregard to human life, that is when criminal liability is attracted. Some of the examples would be not showing interest, enthusiasm or concern in a situation where adverse outcome is remediable by giving immediate attention and the doctor has no care, he doesn't show interest, he doesn't show concern, then criminal liability is attracted. Abandoning a patient requiring emergency treatment, not giving timely referral despite grave symptoms, not referring to diagnostic reports, operating on the wrong limb without consent. Importance of consent has been highlighted by Dr. Rajasekhar excellently well. Leaving behind surgical instruments, gauze, mop, etc., cross-specialty practice leading to actionable negligence, and cross-pathy or quackery. These would attract criminal liability. Now, when we talk about criminal liability, it is important to understand that there is no need of any intention to cause harm. If the act involves a deliberate subjecting to a patient to the risk of harm, it would suffice. If it is done despite being aware of the existing risk, then it attracts criminal negligence, criminal liability. If the doctor proceeds with in the face of such a risk, then it would attract criminal liability. What is essential, very essential to attract criminal liability is a guilty state of mind, what we call mens rea. It becomes an essential ingredient. It is not necessary that the doctor should intend to cause wrong. What would be adequate if he knows that it is likely to cause wrong? It would suffice to attract criminal prosecution. Not the desire to cause harm, but the knowledge or proximity to cause harm is sufficient enough to attract criminal liability. Criminal liability arises when death or injury is a direct result of the negligent act. Act must be proximate and efficient cause. It must be without the intervention of others' negligence. It should be a causa causans, not a causa sine qua non, in the sense that it must be, to put it in simpler terms, it must be the only reason for the cause of death or injury. That particular act would attract criminal liability. What persuades court to lean in favor of criminal prosecution is whether the fact material available on record, the accused doctor deserves to be tried for being imprisoned. if the judge comes to the decision that yes, this doctor, there is material to show that this doctor has done something so grave that he should be imprisonment after trial, then it would lean in favor of criminal prosecution, and the courts will not come in to save the doctor at the very threshold before the trial. I would like to point out, I'm almost at the end of my talk, but I would like to draw the audience attention to the case of M.A. BVG versus Dr. Sunita. Slowly, the courts are also making it necessary for a higher burden of proof. This particular case of M.A. BVG versus Dr. Sunita is a civil case where the parties went to the court to seek compensation. These, I'll just take one more minute, yeah. So these improvements in law or for proceedings in law are being ensured to ensure that doctors focuses on the best course of treatment without being concerned of persecution or harassment, safeguarding medical practitioners to ensure free discharge of their duty. How to protect oneself? Good communication. Rapport with the patient is the best defense to you. Written informed consent documentation, which my earlier speakers have already spoken about it. Good documentation, consent has already been dealt with. There is no replacement for a good relationship with the patient or their family. The most important thing they need from you is your time. These are the potential litigants. How to safeguard yourself? Identify patients who make you angry, patients who are rude to your staff, non-compliant patients, patients who present repeatedly with the same complaint without improvement. I would like to quote that what triggers a patient to litigate, unmet expectations are the emotional equivalents of broken promises. Broken promises lead to disappointment. Disappointment provokes anger, and anger precipitates malpractice litigation. Thank you.
Thank you, Advocate Mohan. That was really lucid and drove all the points perfectly home. The last speaker for today, patient's confidentiality and pitfalls in ophthalmic practice, Dr. Anand Vinekar.
Thank you, sir, and it's a pleasure to present here on patient confidentiality in this very important session. Disclaimer, I'm not a lawyer, but we have some esteemed ones on the panel anyway. So why does confidentiality and privacy come into the realm? Because unfortunately we moved away from the good days where home visits and doctor-patient bonding was a thing to be considered. Unfortunately, healthcare has become so much more complicated. Maybe one can say technology-driven, sophisticated, but also in public hospitals it's crowded. There's so many multiple caregivers. Corporates have entered. Insurances have come in. This is actually on the public health website of India. This is how complicated healthcare has become. Public, of course, we know is government. But then even among the private, you can look at that, for-profit, not-for-profit, and even under those, multi-speciality, specialty hospitals, nursing homes, private clinics. And each of these not only come with multi-tier, but they come with a whole lot of compulsions in terms of sharing and maintaining patient data. And with all of this then comes confidentiality, and then from there privacy, and then let's talk about that. So if you just look at the English language definition, it's something that something private. So it has been traditionally described for something that remains at home. So that could be related to family, motherhood, procreation, sexual orientation, things that are changing in this century. But historically, the Harvard Law Review first spoke about it. And interestingly, privacy was first talked about as the right to be left alone because of a whole lot of print media and defamation cases, and that's when public figures wanted to stay private, and then their private lives are being exposed to the public. But what is it in the Indian scenario? So if we have to claim damages of privacy breach, we either have to go against the state, which is the government, or non-state agencies. And since healthcare falls under these two verticals, it's probably important to know both. Two important cases that have defined what the courts look at for privacy is one is the Kharak Singh UP, where just because somebody was a history sheeter doesn't mean that he had to be put into jail every single time there was a crime found in his locality. And then the whole thing about procreation and the MTP Act, the HIV Act has led that in terms of a woman having autonomy of her sexual preferences and times to do abortion and so on. But probably the one that's most famous is what's called the Justice Putswamy case, which was actually an Aadhaar case to look at the validity of Aadhaar, but then the Supreme Court then ended up describing privacy and made it a fundamental law, fundamental right, and that is under Article 21, which is the same as the fundamental right to life. The non-state agencies are, we actually have a mandate under so many verticals, Convention to the Rights of the Child, and having privacy issues with a child, with a minor, is probably even more complicated than, of course, the European Union and the United Nations. And from all of this comes the fact that we have different sources of information of our patients, and therefore how we tackle that and how we receive that is something that is very important. On one hand, you are supposed to receive it as a healthcare provider, and on the other hand, can you actually divulge it? And if you can, and you must, then to who? And that's what we look at. So why is it so important? Why are we even talking about confidentiality? Because if the patient doesn't trust you, he or she is not going to give you information that's vital for his or her own care. And isn't that what we all want as medical professionals, is to do the best for our patients? So if there's no trust and there's no privacy, then there's a problem. Now, in a corporate setup or in a multi-speciality hospital, unlike a private practice or where you're just dealing with the patient, you have multiple tiers. You have a nutritionist who probably knows he or she is a diabetic. You have a physiotherapist who knows he has some disability. And all of this information could go against the patient if the patient is, let's say, looking for an insurance. So therefore, the ethical and the legal mandate then becomes important, because we have at our disposal a lot of information that we may not have or may not need, and then definitely not supposed to share. Yes, we are bound by the Hippocratic Oath, the ICMR biomedical research, and Dr. Diwakar sir also mentioned the NMC 2002, which the rules came out more recently, but I think has been put in abeyance. And of course, highlighted in the media a whole lot of these kind of facts where, this one was perhaps the doctors did well, because we still don't know whether it's suicide or murder. And we're talking about Hippocratic Oath now, slightly modified, and this is in the NMJI, where they really talk about confidentiality. And this is about, I'll respect the secrets of the patient, but take into confidence the family for the purpose of the best treatment of the patient. So this is something going beyond what we really talk about. And it's built on trust. If the confidence is lost, the trust is lost. And if there's no confidentiality, then there's no trust. So patient autonomy, what he or she believes he should tell you, the doctor's integrity to keep that information, and then what happens if you let that out. Yes, there are exceptions. This is not an absolute right, as many are in our constitution. The fact that, let's say there is this disease that is going to give rise to the family members to be affected or infected. Like this tuberculosis case makes it, you are supposed to be notifying tuberculosis if this happens, and then you have to, and this can actually help the patient as well, because if you tell the caregivers that he has tuberculosis, he's more likely to be compliant with the anti-TT medication and so on. So in the Indian context, you are, unfortunately, anyone walks into our outpatient and says, I'm the brother-in-law of this patient you just saw, tell me what's wrong. And in our good faith and probably not knowing the law, we would just confide in that person just because he or she claimed to be a relative. And that is legally wrong. There is no locus standi for that patient, this human, to just walk in and say, I'm brother-in-law, sister. Even if it's spouse or child, we have to be really careful, because unless we have the permission of the patient, we might be divulging more than we need. And if you find that the adult is incompetent, and we talked about valid consent, there's also a valid person who can give this consent to make this public, then you must bring the family that is involved. So what types of disclosure? So this is where, how do we as healthcare professionals get this information? One is by consent. So we write out a consent, and that's been detailed. The other one is the patient himself or herself goes out and says this is it, and sometimes some of this information is put onto the public platform. And then of course in public interest, where most of the time it's by the law of the judge wanting us to come out with it in court. So this is how consent, in the informed consent, the fact that this information will be kept. Or this, for example, this case in the UK went, the hospital was not held negligent because this information was already made public on a platform. But let's say as a psychiatrist or as a neurologist, you know that this school driver, bus driver has seizures, and he's driving a school bus that involves children. So you, as a healthcare professional, you have this information. Should you
give it to somebody? There's public interest here. And if you have to give it to somebody, who would you give it to? Would you give it to the principal, the school teacher, all the parents of all the children sitting in there? So these are the gray zones, but they have actually been fairly well defined in law. And this is, one caveat that we can all remember, that your privilege of privacy ends as soon as it starts affecting public ill health or disease. And we spoke about tuberculosis, we'll speak about HIV as well. And therefore, we are fairly, we are bound under this new law, and Diwakar sir mentioned this, that we now have these rules, and the rules have more recently come out. And I've taken, from the rule itself, look at those three things in red. They're certainly something to do with the healthcare. Passwords, financial information, yeah, why not? But then mental and health conditions, that's exactly where we as doctors are going to be. Sexual orientation. I mean, today, patients are going to be known by the pronouns they keep. How many of us are even trained in being sensitive to that? And of course, medical records and history, that's going to be germane to what we are doing. So any information that's available on the public domain or that has come out because of an RTI, that's an exception to the IT Act itself. So again, if you're an outpatient, you say it's rather simple. But if you have a multi-care hospital or you're working for let's say a teaching hospital or a medical college hospital, then the shared responsibility is a problem. So this is really important in terms of what you must explain to the patient that you can do. So you have to tell the patient what records you're taking, in what detail you're taking it, how you're recording it, how you're storing it, who are you going to divulge it to, and most importantly, are you going to delete these records after a certain time? Unless you put in all these 6 ingredients, you've not really, followed the law. So assurance that the data is being collected for lawful purposes, what information, what it will be used for, and who will have the access. And if it's going to be shared, who's it going to be shared for, shared with, and then how long will it be shared for? Now, unfortunately, we don't have medico-legal law confidentiality rules, and therefore we have to unfortunately come under the gambit of banking, finance, CA, IT, and so on. And in the US, they have the HIPAA, and a lot of the EMRs that are being developed in India are now following HIPAA. But right now, we just have the IT law, IT Act. The time limit for the data sharing he's mentioned, and it can go anywhere from 2 to 3 years to 7 years to 10 years. And I just wanted to add to that information that Sir gave, is that if you're a child and you're dealing with a child, you have to keep it for 3 years beyond 18 because that child has the right to sue you until he or she is 21 years of age. So that's something if you're dealing with the pediatric population. So these are the exceptions for the absolute confidentiality, HIV, sexually transmitted diseases, sexual orientation, mental health, and substance abuse. The HIV Act is splendidly written because it is so, it moved away from making HIV a taboo to something that we have to accept. And so many cases have been lost by employers who had, deleted and not allowed people to work just because they were retrovirus positive. And I think that's something, the confidentiality breaches are so, if one has to understand how you can breach confidentiality, one must read this act. So unless you are within the court order, you must not give it. Yeah, I'll finish. So you must encourage somebody to, even if it's a spouse, you must encourage that spouse to go and tell the spouse. And if you're reasonably sure that he or she is not going to do it and that is going to transmit, then you have the right to divulge this information. So in summary, confidentiality rests on the fact that the patient's information should be a patient autonomous thing. It is our legal and ethical mandate, and I've shown you the newer acts, and the IT rules are a good point to go by, but counsel well and document even better. Thank you.
Thank you to all the speakers. We'll now have a session which is totally interactive. We're looking at different scenarios, and to the advocate fraternity, it's also to tell you that the people we're talking about is a spectrum which can mean huge institutions with more than 500 doctors, which are medical colleges and institutions. You could be talking about individual corporate houses like Aster, Manipal, etc. You could be talking about family enterprises. You could be talking about individual doctors. So your answers may vary in spectrum because different people get affected differently. Different, like all the doctors here on stage are very powerful, noted people, so they have all the clout and power, which is very different from people like me who have no power, have no contacts with the police. So you would be affecting people like me and big shots like Dr. Rajasekhar. So with those perspectives, I would like you, rather than having something purely theoretical or what actually, we want you to speak from the heart and what happens. And actually this panel has been invited basically to take care of actual scenarios and problems doctors have faced, and I know that all of you all have handled medical legal cases, so, and of course Mr. Mohan is a veteran in this for several decades, not years. So with due respect to all of you all, we'll start. My first question is, which is typically what happens in any of these medical legal problems or situations, it's that doctor suddenly gets a phone call, or a constable comes to your office or to your clinic or even to your hospital and says, "Nimmala complaint ಇದೆ, there is a complaint against you. There's a complaint against you, and the inspector wants you to come there because you have to give a statement." Now that's all you know. You may know sometimes who the patient is because obviously he has tickled you quite a few times. There may be situations where he's not, and it may be quite a surprise. I will probably start with the junior most lawyer here, Aline. I'll ask her to answer this, and let's see how it goes from there.
Good evening, everyone, and thank you so much for having me here. As far as I've seen in the practice, immediately as soon as a doctor gets a call from the police or gets a visit, the first thing is to go into a state of panic. So the first and foremost is to remain calm and to try and get as much information as you can on the call itself from the police as to who has filed the complaint or what it is about. Thereafter, you can always go to the police station, and it is advisable that you discuss this with a trusted colleague who is willing to accompany you to the police station and to go there, and foremost is to read the complaint in its entirety and to understand what exactly has happened or what has been written, and to gather as much of the details that you can from the complaint itself. After that, generally in what happens in reality is that sometimes it's one of the junior most police officers who are there, and they'll tell you wait for the inspector to come and meet this person, meet that person, etc. What the advice that I would give is that foremost you can tell them that I'm a doctor on duty, and therefore check.
Hello. Check. Hello. Hello.
Me now? Fine.
Check.
Okay. We were with accompaniment to the police station.
Thereafter, if so as I was saying, generally they'll ask you to wait, meet the inspector, come back, things like that. You can inform them that you're a doctor on duty and that you'll go back, check the documentation and come back. You can always go back, check the patient's file or case notes, go through it. If there are any other cross-references of any other doctors who had treated the patient, you can always have a discussion with them and go through the entire case notes and understand what actually happened. Thereafter, you can go back to the police station and inform them very clearly that there has been absolutely no negligence and these allegations are baseless or found on more emotions rather than actual documentation or data that the doctor can provide. Now, even after that, or despite this, if the police threatens to file an FIR or to go ahead or proceed with their own investigation, it is your duty to inform them. This is where it is very important to know your legal rights also as doctors, to inform them about this Jacob Matthews decision, which is the most important decision for doctors, which clearly states that a doctor cannot be arrested nor an FIR registered against him unless it is backed by an expert medical body opinion which says that the doctor has been negligent. And this is very fundamental for you all to inform the police. Even after that, if the police go ahead and register an FIR, despite that, if the police still go ahead and register an FIR or continue with their investigation, you should contact your lawyer and immediately approach the High Court and file what is known as a quashing petition to quash the FIR at that stage itself. So this is the procedure that any doctor should follow when they are threatened with an FIR or an FIR is filed against them.
Okay. As a matter of fact, I think it's happened even when Minto had a problem. They had filed an FIR against some of them, and for whatever reason, the police refused to withdraw it, which gives actually you need to send a note and letter to them, and possibly with a you can email, because all their emails are available on the net. You can send them an email with a copy to the DCP and the commissioner, and immediately there will be action, because at least at the higher levels they know that this would mean action against the police. It's if a police inspector or anyone files an FIR against a doctor without a medical thing, he is liable for disciplinary action, and that's the last thing a cop wants. And so the minute you do that, they would go on their backs. But if it's already done and reached the court, you have to move heaven and earth, which means a lawyer, and get it quashed, which the court will immediately quash, because it is guided by the Supreme Court and by the law. Okay. Coming to the next question, this I think I'll leave it to Karthik and thing, because they have first-hand knowledge about this. If you get a notice from Dr. X gets a notice from a lawyer on behalf of patient Y saying that he's had a cataract, and Y, that's the patient, and that the patient's vision has not improved significantly. He then demands there that because my vision has not improved, you have to pay me 1 crore as compensation. And he threatens, in his letter to you, he threatens you that he could go to the court, he would go to the KMC if you do not pay it. Either he may send it or he may send it to you through a lawyer. As a doctor, Karthik, if you were to get this, you're a young doctor, just beginning practice, you've done a few surgeries, I wouldn't say 100,000, whatever be the number, and presume you're in a small setup. How would you react to this notice or a letter from him or from his lawyer? What would be your reactions? And this is something many doctors would face, especially if, I mean, in Bangalore, you may, like I said, some people may have the clout, may immediately get a lawyer and things like that, or you may have the thing. In certain areas, especially in semi-rural towns and things, you don't have access to all this, and suddenly you're hit, and you're a very young doctor just waiting to make a name.
Yeah. So, once you get a notice, you start seeing every registered post which comes in a brown envelope with a lot of fear. So, yeah, the first reaction is panic, a lot of panic. And there are also thoughts that why don't you call the patient and settle it down, or why not approach the advocate? Sometimes it's as bit as why did I take this profession? Why not quit and do something else? So these are the thoughts that usually come to the mind. It's mostly reactionary. But yes, once you have gone through this, you do learn a lot of understanding points. That once you get an advocate notice, it's just an advocate notice. It is not a letter that is coming from the court. So you are required to answer it to whatever extent the allegations are, but don't have to be afraid of them. It is advised that once an advocate sends the notice, it is not necessary for us to anymore have any kind of interaction with the patient directly. It is whatever communication has to happen, it has to happen via our advocate who is going to represent. One of the first things that needs to be done is to secure all the documents. It may be EMR, it may be written records, it may be consent forms, it may be video consents, it may be audio consents, patient telephonic conversations. The list is we'll have to think about it and secure all the records. If we have EMR, there is an option to lock the records so that these records may not be shared with somebody else because of wrong interests. The next most important thing is to look at our indemnity. I think most of us are not even sure about what kind of indemnity we have, what it covers, what it doesn't cover. Only after receiving, you start looking through it and find out that this indemnity doesn't even cover this case. So I think it is very important to look at our indemnity, the pluses of it, the minuses of it, and then work on it. The next most important thing is to inform the insurance provider. As a doctor, we are supposed to write a letter to them, and most of the insurances do not reply back at the first instance. So do not stop until you get a reply from them. Keep writing to them, keep communicating with them till a reply is received from the insurance company, because there have been many cases where they have denied processing the claim because they were not informed. The next thing is that whenever there's an...
Karthik, I'll stop you here.
Yes.
Is there a tendency for a minute, don't think it's you, but just consider yourself as a young doctor again in town getting this. Is there a tendency for you to go into panic, but since the lawyer has said you have to respond within 15 days or you have to pay up 1 crore or I'll take you to court, is there a panic situation where you think that you need to write the letter yourself, you need to respond to yourself? And immediately after you say this, I will ask Vaibhav to say why you're right or wrong.
Yes, sir. I do feel that we have to write up our points of reply, and then that has to be verbally or drafted by the advocate.
Okay, so there is a general tendency that you go into panic, you don't know what to do, you got a letter, and and especially if you are even called from the police station and told to respond to it, you think that you have to write the letter. Vaibhav, tell me why you would think that that may not be the best way to go ahead.
Good evening all. Thank you for the opportunity. So one of the main reasons is emotion. Right now, the first and foremost, when you're emotionally involved, you're bound to make a mistake. And at the same point in time, any notice that is received by any doctor, what we need to understand is, though it has no legal essence, if you receive a notice from an advocate, it is very important because it's a foundation of a case. So your foundation has to be very strong, because if we make a mistake in any of our responses, that will hurt us till we reach Supreme Court, and it will hurt us in the Supreme Court too. So the best is, not all lawyers will know everything, but it is safer to assume that all lawyers will know the law, and therefore to go to a lawyer, approach a lawyer, and thereafter get a response drafted, I think that's the safest approach one can have. Going by yourselves, there are mistakes bound to happen where procedural aspects are not taken care of, and that could hurt the case of the doctor also.
Absolutely right. Now, Karthik, you send a notice through your lawyer back, you're given a reply, and by the time the reply reaches there, 3 days later, you get a notice from the KMC saying that the same complaint for lodged at the police station has reached the KMC. How would you respond to that? Because now you first of all, blown your head off because you just got a lawyer and you realize that, you think that the lawyer can handle things. He sent a notice back, but now you get another notice from the KMC, like you said, brown covers come, the next brown covers come, and he tells you now you get 15 days to respond to this. Otherwise, what we will take legal action, disciplinary action, etc., against you. How do you respond?
Again, over here, sir, I think we can look at the case, and I think the KMC gives provision for us to seek additional time in case we will have to take an in-depth thing, and it has to be discussed with the advocate, and I think the advocate also should be made to understand the medical aspects of the case so that an appropriate reply can be drafted.
Okay. 2 days later, so you have a advocate who you picked up, and together you'll frame up your reply and things like that and give it to the KMC, and 3 months later you get another notice, and that comes in the consumer court, and he tells you that because he says 1 crore is pending, and what do you do next?
I think it goes further, sir, as to we have to draft a reply again to the consumer forum, but with less medical terms in it, and to say why we are not liable to pay the amount, and also to make sure to express the things which are in our favor, that things were explained and things.
By the time the lawyer has already demanded X, Y, and Z quantums of money for each of those notices, and then you think whether you should employ the best medico-legal expert. So Mr. Mohan comes in. Mr. Mohan, how would you advise your client now? Sorry, I'm going by first names because I believe in being cool.
No, please, absolutely. Am I audible?
Yeah.
So the question is how I charge my fees?
No. That I'll ask you last. Okay. Now, what I'm saying is, he's now hit with 3 components. One, the first is a legal notice. He's hit by a KMC notice. He's hit by a consumer court notice. What would you advise? How would you go handling this situation?
Yeah. See, by now I think that young lawyer whom you were referring to get seasoned. I think the first job of a lawyer would be to counsel the doctor rather than talk about the complexities of the matter before him. A lot of people come with a lot of misconceptions. And let me assure you that in the past, about 90% of the cases were frivolous or misconceived. Now, quality has improved, quality of the complaints have improved, but even then, I think a little over 50% of the cases are still misconceived. There is really no need to panic. I think the first thing that the doctor must do, because not everybody would know a lawyer or a lawyer who specializes in medical malpractice litigation. So I think peer bodies like this play a very vital role in trying to connect the young doctors or a doctor who has never been part of a litigation to the correct specialist. So I think a good lawyer would definitely instill courage, wash out the fear in the doctor. I think that would be what he would primarily do when he meets the lawyer, meets the doctor. So I think by the time the third notice comes, the doctor is assured that nothing is really going to happen. And if there is a culpable case and if documentation is not available, consent is not properly taken, I think a good lawyer would also suggest to the doctor to find a way or a means to get out of trouble.
Mr. Mohan, the other question I have is, in your experience of several years, how many cases or on an average, how many really get, tangled with verdict from the KMC that there is negligence? And how many times have you seen the word gross negligence being used? Because that's so critical. Say in about the last 25 years, which I'm sure you have, how many times from the NMC or KMC have you seen, say if you had 100 cases, how many times have you seen negligence being attributed to the doctor? One. Two, among them, how many times has the word gross negligence being used? And how important is these two terms when the complainant or the party, thinks of going criminally against you or then putting in an FIR? And how strong is the word negligence to put an FIR? And how strong is the word gross negligence? Or in other words, will negligence give them enough power to file an FIR, or do they need gross negligence to file an FIR?
A lot of questions. Let me. Yeah, if I forget to answer any one of them, please.
I'll come back.
Yeah. See, almost all of these things happen simultaneously. The party goes to the police. He lodges a complaint there. The complaint usually is referred to the KMC, and he may also go directly to the KMC and also parallelly before the consumer court. So all these may happen simultaneously. The consumer court, the KMC, and the police. The police. There is a circular issued by the DGP, I think, just pre-COVID period, where they have circulated this to all the police stations, giving them guidelines as to what protocol they must follow. Of course, this is in pursuance to the judgment of our own High Court. This has been done, but it has been circulated and forgotten also. The police are not going to register an FIR. Somewhere down the line, this thing has settled in their mind. Usually, these wrongdoings are done at the behest of politicians, the local goons, etc., etc. Of course, those numbers are very less. Now, coming to the aspect of number of convictions or punishments imposed by KMC, I think not more than 10%. I think that should be the fair number that I can quote. Not more than 10%. And the word gross has not been taken so seriously by anyone except for people in the conferences like this. And when you read in judgments, police don't know how important that word gross is. KMC, I have never seen any order where they've used the word gross. Fortunately for all of us, KMC is doing a phenomenally wonderful job. I wish you had won the election, Dr. Reggie. You would have been there. You would have been entitled to this compliment as well. KMC is doing a phenomenally good job now. There are people who are more aware of what the law says and what should be done. They're more eager to do a good job sitting there at the KMC. The Saturdays have never been as exciting as they are in the recent times. So this aspect was actually discussed just about a fortnight ago, about the fact that they have to use the word gross. They have themselves been battling a conflict of interest with the police and their duties. Because because some of the cases are being referred to panel of experts in government hospitals. And what happens is there is a long standing consequence when an FIR is registered. So borrowing an opinion from a government doctor or a committee of doctors from the government hospital has its own dangers, because no proper inquiry is conducted. The delinquent doctor is not interviewed, his perspective is not considered. So all these are done merely on the basis of the medical records, which may or may not have reached them in its complete form when it has been seized or given by the hospital. So these are the pitfalls. KMC is eager, and they are right in asking all these matters to be referred to them. But then the police is frustrated because they don't want to keep any files pending. KMC is to do the due diligence. It takes time. They say only once in a week, and for a case to be decided, it never happens in 2-3 years, because they are hard pressed for time as well. Because each time you go to KMC, I think the next best or the earliest date that is being given by the KMC is a month. And if there are directions by the High Court of shorter dates are being given, they are hard pressed for time. They have made smaller benches, unlike before there used to be just one hall where proceedings used to go. Now there are at least 3-4 halls where proceedings parallelly go on. It's a fantastic thing. It's a big step forward for doctors and good for lawyers also, because a difficult question to answer to a doctor is how soon their cases get over. Okay, so yeah, have I answered all your questions, Doctor?
Yeah, most of it. Karthik, you had something to say?
Yeah, so you just mentioned that these two run in parallel, the consumer case and the KMC. Is it possible that both of them can give contradictory orders?
There are ways by which you can sort of hold the consumer court to some time, saying that because there's a Supreme Court verdict which says that it doesn't say may, it says the court may not be competent enough to take a decision in medical legal cases and shall get an opinion from the thing. So based on that, you can hold it for quite some time and wait, pursue them to wait. But if something is absolutely obvious, there are provisions by which the consumer court can go beyond that thing. Am I right, Mr. Mohan?
Yes, sir. Both consumer courts and KMC have in their statute the time period within which the court cases must be decided. The time frame before the KMC is larger than the time frame for consumer court. Both are hard pressed for time. The greatest challenge is we are too big a population. We have too many problems to solve, and we have less infrastructure in terms of court establishments. And the question was whether there could be conflicting decisions. Say suppose there is a verdict of the Medical Council that the doctor is not at fault. The doctor is not at fault. It does not mean that the consumer court should simply close the case based on the verdict of the Karnataka Medical Council. The court can still go into the aspect and see if all the points have been considered by Karnataka Medical Council. There is no bar for the consumer court to rule against the doctors, despite the fact that the consumer court has ruled in favor of the doctor, if the court finds reasons. And that opinion can be based on medical literature, on opinions borrowed by the court, or expert coming and reducing evidence before the court, which benefit the Karnataka Medical Council may not have had. Because there there are elected members, like there are 16 people. These 16 people may not be well versed in all the specialities, or the person whom they have consulted, the outside resource person, may not have paid attention to that particular issue.
Okay. If the consumer court, can the consumer court, for example, I'll give you a simple example. Patient comes in a relatively fit state for whatever reason. Patient had a surgery, went into some complication, patient passed away. It's really no fault of the doctor, but can the consumer court still, on the basis that the fact that the patient went in well but came out dead, can the consumer court still give a compensation?
That's the job of the lawyer, to not let it happen. Yeah, there have been instances. There are bright judges. It's a total representation of the society. You have all kinds of people in all places.
Okay. Next question to Dr. Rajasekhar.
Very subtly said.
Yeah. Dr. Rajasekhar, suppose there is a patient who you operate for a cataract surgery. For whatever reason, patient develops a vitreous hemorrhage, or patient, you have a nucleus drop. Okay, that's a complication of, just for their information, it's a major complication when you do cataract surgery. Most often a patient who comes cataract, expects to go back 2 days later, go back within 2-3 hours, presuming that he can see everything, and 2 days later, they claim that they can do almost everything. But here he's had a complication. He's not a high-tech surgeon. He has basic equipment, and this is a complication. Either Dr. Rajasekhar has to call in a vitreoretinal surgeon from outside, which means obviously he has to pay him quite a lot to do the second component of the surgery, or he has to close the eye and refer him to a vitreoretinal surgery where he needs an additional surgery. Now, the first surgeon, the cataract surgeon, has told him that he'll do the whole cataract surgery, everything. It would cost about 50,000 rupees. But unfortunately, because of this complication, the effective bill comes to about 90,000. The patient says, I am not going to pay. How will you handle it, Dr. Rajasekhar?
See, here, one is handling the medical part of it. Second one is the financial part of it. With regard to the medical part of it, the doctor, whoever is handling, should do the right thing. If he has the capability to complete the whole procedure by doing a vitreoretinal surgery, he can go ahead. If he has immediate access to a vitreoretinal surgeon, he can do that. If he doesn't have these two, he should not do what he can't do. And he should close the case, explain everything in detail, document it, and refer and explain it to the patient and the relatives in a way they can understand the whole thing. The financial part is not part of this, because you don't get into a fight with a patient who is already aggrieved. So that has to be amicably settled. So that shouldn't be a major issue.
My question is, patient bill comes to 80,000 from 50,000, and he gets the bill. And when he sees that, he says, no way, as it is, you've given me a complication, now you're going to tell me to pay for the complication. How will you handle that?
Yeah, see here, we get both kinds of patients. Some people, are willing to pay for, to get over the problem. Some people, they don't want to. So you will never get into a fight. You may absorb the costs, because already he's traumatized, and you can't push him further. Because that is where the balance tips there.
Question here is, now, you've given him a concession. He's got the first bill of 80, then he's got the bill, okay, Dr. Rajasekhar gave him a concession, it's only 50,000. Very good from Rajasekhar's side, but he sues you because his vision doesn't improve very much, and says this is proof that this happened.
No. Here, it's not the question of concession. In the first place, you don't try to charge a person who may or may not be ready to pay. If you get a person who may be ready to pay, especially if you refer to another place, then he'll pay and the things. So basically, you don't get into a fight on that. At the same time, you don't show generosity saying, I'm going to absorb the cost, I'm going to pay you money. You don't show up your guilt also, because these things can happen. And these things are not due to negligence or anything. These are like any other accidents that do happen. It all depends on how you communicate to the patient at that point of time. Okay. Showing guilt is absolute no here.
Dr. Anand, your comment?
No, I think from a legal point of view, there is a difference between guaranteeing an outcome and doing a reasonable care. And legally, no one is going to guarantee an outcome of a cataract surgery. And if there's a complication, a known complication, which has probably been explained in the consent, there's absolutely no need to subsidize or pay for the patient, because as one, it might even be held that you're doing it as a sign of guilt. But secondly, that is not even a requirement legally if you followed the standard of care.
Totally agree. My only concern here is, can this, like Dr. Rajasekhar said, you always feel bad. Yeah, whether they pay or not, a doctor feels terribly bad when something has gone wrong. Okay, it's like your own relative going through something, there's no doubt about it. Can this patient, my only thing is, can this patient use this as a weapon to further augment his case against you, Mr. Mohan?
This, I don't know how to answer this question. It's a little bit of a jinx. Absolutely. I think the focus should be on the beneficiaries of this augmentation. It is very important to mitigate situations, and this can be done both people with the white coat and the black coat. I think communication plays a very key role in all these matters. I think a doctor must be trained, exposed to deal with situations, complex situations like this, and give it a closure, or contact a lawyer also at the same time. Yeah,
I think that's true. Every step should be taken to mitigate any situation, and patient should recognize concern as being significantly there on the side of the doctor, and I think that makes a big difference.
See, the patient is not aware as to what your degree means. He just knows a content doctor. He knows that you're an eye doctor. He does not even know that you're an ophthalmologist. Yeah, then he doesn't know how much you scored in your graduation, undergraduate, post-graduation. All that matters to him is how nicely you spoke to him, that you patted him on his back.
Most of the patients doesn't want to go to the court or lawyer. They want the outside court settlement. They ask. So in that some arbitration can be done or amount can be done.
Next question. What is the role of arbitration in any medico-legal case? How can this role or this component be incorporated into the system? And can a clause like this be added in the consent, or where do you incorporate it? Is it an independent document? And if at all it comes to arbitration, who will do the arbitration and who bears the cost of this arbitration and things like that? Arlene.
So when it comes to arbitration, it's an alternative to going to a court or to a traditional mode of legal disputes. Arbitration is seen as a method which is faster, less adversarial, confidential, so therefore a lot of people adopt it. However, it's not yet adopted as much in medico-legal cases. Now, when you ask whether an arbitration clause can be included in a consent, there are certain drawbacks in that. Firstly is that when a patient comes and is signing a consent is to tell you about the treatment and what are the risks. Now, by putting in an arbitration clause into it, it sort of puts the patient in a position to sort of doubt the competence of the doctor or the competence of the procedure, and then they soon begin to wonder, what exactly is going on when they sign this consent form, what else are they consenting to? So it already puts you in a bad image in their eyes. Secondly, what I was just discussing with Sir is that when you put an arbitration clause in a consent form, now for an arbitration clause to be held or enforceable, it has to be a stamped document. So now when your consent forms, you can't get every one of your consent forms stamped with paying that stamp duty, etc. It is very difficult to enforce this arbitration clause and without an arbitration clause in either a separate agreement or in the consent form, you cannot go into arbitration, because arbitration is a procedure that can take place only when both parties have consented to it prior. So it has to be in writing and both parties should have consented to it prior. So now these are the drawbacks of incorporating an arbitration clause in your consent itself. So it is very difficult to do the same. You can always have a separate arbitration agreement itself which can be explained to the patient and they can be made to sign it by maybe your HR representatives, etc., rather than making the doctor do it themselves.
Who can be an arbitrator?
So as per the Indian Arbitration and Conciliation Act, any person can be an arbitrator. It can be a retired High Court judge, it can be a medico-legal expert, it can be any other person. It has to be an odd number of persons. So it can be a sole arbitrator, it can be a panel of 3 arbitrators, which can be decided through the arbitration clause itself, where you'll decide how the arbitrator will be appointed, what are the points of dispute that can be referred to arbitration, where the seat of arbitration will be, what is the language that will be used in arbitration, and if this arbitration clause does not specify the same, the arbitrator can decide that. Now, when it comes to cost of arbitration, it depends on various factors. Now, if the claim of the patient or the complainant is much higher, the cost of arbitration goes up. If you select a sole arbitrator as compared to a panel of arbitrators, once again, the cost of arbitration goes up. Additionally, if the seat of arbitration is away from where the doctor is, then again, the cost of arbitration for travel, for the doctor's loss of pay, etc., that way your cost goes up. usually both parties bear the cost of arbitration, but at the in certain instances when the award is given, it can be, the liability can be put on the party who does not succeed through the arbitration.
Okay. Since we're running short of time, Mr. Mohan, how long do you think, on an average, medico-legal cases take in the KMC or the consumer court? And the difficult, or not the difficult, the tricky question is, what would it mean in terms of cost to the doctor to have a high-quality medico-legal expert? Because you never know when the doctor, believe me, it has happened. Doctor thinks it's like going to a court; it's a one-time thing, and he goes and explains, and he gets a reply to it, and he comes back and he tells you everything is done. But that's not the reality. It sometimes goes on and on. So how? I mean, I'm not saying about real numbers, but what would you expect the doctor to presume would be the cost of a medico-legal case and a consumer court case? And the second component of that, if you are covered under insurance, does the cost of hiring a good lawyer, is it acceptable by courts, or do they have certain fixed amounts for a lawyer, and does it take care of all court fees and et cetera, et cetera?
Thank you. There are two things. Insurances which an individual has taken, they will not cover lawyers' costs, many of them. Some of them do. It depends on what choice the individual doctor has made. Some of the peer bodies, like Foxy, for example, has a very well-designed system where they have accommodation for lawyers' fees also to be paid. There are some institutions which have come up, which have promised that they are going to take care of the lawyers' fees also, and they are offering insurance. But what one must be concerned about is the people handling the litigation. Do you know them? Do you get to choose your lawyer? That's the question. Because I have appeared for insurance companies during the early part of my practice. I used to be a lawyer for Bajaj Alliance and New India Assurance. So they have a run-of-the-mill setup. So case one comes to gentleman A, B, C, it's rotated like that. So the lawyer doesn't care. He's not emotionally attached to the case, and he doesn't know the client, and there's no one-to-one between the client and the lawyer. So that sort of reduces the quality of care during the litigation process. Next question was, how long does it take for KMC to decide on a matter? There have been matters which are pending for 5-7 years or even longer. But like I mentioned, and I would like to reiterate, is that things are going to become quicker. And I see that things may be disposed of in 2-3 years time frame. So also the consumer courts, 2-3 years, I think, roughly. But you must remember that you won't be going to court on every day during this 2-3 years. Sometimes the dates may be given on the next week, or sometimes the next month, etc. Or it may be going on a day-to-day basis when it concerns stages like evidence and arguments. Now, lawyers' fees. See, a lawyer, I actually smiled when I saw this question on that write-up that you sent. I would like to divide cases in two types: chronic and acute, malignant and benign. All right. So when you come with acute instances, like you want a bail, so I can tell you what is the offense, the affair is here, you need a bail. So I give you a package like a discectomy, a tonsillectomy, or a C-section, right? Then I tell you it's going to cost you 50,000 rupees, 1 lakh, whatever. And if it doesn't happen in the sessions court, we need to go to the high court, and it's going to cost you so much. It's very easy for me because I know the scope of my work, the scope of my responsibility. But when you come to me with a complaint where it's a fairly complex case, I do not know how many witnesses the complainant is going to examine. I don't know how long it's going to take for me to cross-examine those witnesses. I don't know how cooperative this particular client of mine who has walked into my office is going to be, because many a times I have seen, I counsel them and tell them, doctor, don't worry, he doesn't pick up my phone also. That's the problem. Then I ask him, please send me that literature. I have to make 10 phone calls to him. So my fee structure depends on the amount of time that I spend on the case. The first meeting, I charge them about 10 to 20,000 rupees because that gives them an eye-opener. That gives them an understanding as to what they are likely to deal with. Then they are also going to experience a little bit of the lawyer's perspective about the way that the documentation has been maintained. So I'm going to educate that doctor also in order to how he can avoid future litigation also. So I'm enriching that doctor also, not only defending this case. Several aspects like this. But what doctors must remember, this is a very important question, because what doctors must also remember is the lawyer is going to be in the field for long. He is not going to look at you as a hen that lays the golden eggs, right? So he is also going to be careful about the fact that he has to be reasonable in his approach. Have I answered your question?
Yep, absolutely.
And no lawyer is going to be, going to look at a client as a money machine, unless it's one of a case that he has never dealt with and it comes and the doctor does not know that there is a fairly large number of lawyers practicing on the medical malpractice litigation.
Dr. Diwakar, just want to know how important it is for a doctor to involve an advocate, however simple the case may be.
It's good actually because Association of Medical Consultants is in Bombay and in Karnataka, Bangalore also we have started, for which I am the in charge of president. So here the indemnity insurance, the AMC, they appoint advocates. They got in their panel. So they will to look after the lawyer's offices, his travel, everything they will look after. So it is better to have contact with good indemnity insurance from recognized companies you can take, which are recognized for the covering of all the charges related to the case. And also, it is always better to contact an advocate if you get any notice from any of the advocates, any of the patients, or any complaints, or even if or from the patient's complaint through an advocate. It is better to consult an advocate and take his opinion before proceeding further.
Last question, Mr. Mohan.
Yes, sir.
In your vast experience, what are the weakest points that a doctor, that you have seen in cases which has led to calamities or at least put doctors in at a disadvantage because of different reasons? What do you think are the commonest reasons? Like, he may have done everything correct, okay? He's done the surgery according to the standards, his OT standards were perfect, he's done everything. But there are lacunae in what has caused him to possibly lose in the consumer court or have to give something in the consumer court. To the KMC finds, small pits or lacunae there. What are the commonest, things which look that, would have been there by default but are not there?
Very, very important, and not much importance is given. Many doctors don't realize that their post-graduation is not registered with the KMC. I have seen doctors who are aged 60 years, they have not gone back to KMC and registered their post-graduation. Yeah? Very surprising that, of course, it has been due to inadvertence. Of course, now there are certain changing norms with the KMC also, which has made it mandatory, and you have to attend CME. CME points have become mandatory, and paying registration fees on an annual basis, of course, which has now been put on hold. These things have prompted doctors to ensure that their certificates and registration are up to date. The biggest problem that I am seeing is the corporatization of the medical sector. This has brought a huge gap between the patient's interest, the doctor's interest, and the hospital's interest. Very sad, very sad. See, I don't know how many of you are hospital owners. I don't want you to beat me up outside.
No, may happen inside itself.
Not with you, Dr. Raj. See, entities, corporate entities are there to make profit, right? So their interest is different from a doctor's interest, right? So I will not say much more than that. Then comes the issue of consent, improper consent. Even today, despite so much of stress being given on consent, even today consent forms are not in proper order. Nobody bothers, no institution bothers to go to a lawyer and ask them, see if their consent is in proper order, their format is in proper order. That's one thing. Documentation, record keeping. Many doctors don't know how important it is to maintain proper, accurate records. Very wisely, those two topics were chosen for today's discussion, and I can't give enough emphasis to those two very, very important aspects.
I think you're absolutely right. We think that consent is though we discuss so much, we talk this much, and personally I am guilty of it, and I'll tell you that many institutions are guilty of it. It's something which is left there, and we presume that it will be filled by default.
Correct.
And it's not filled the way it should be because we do not have the time, and we think our juniors will be careful enough to go through it in detail. And again, like very often when we go on rounds the next morning or the day after that when they come, sometimes the complaints are so subtle, we just put two letters there and just say 6 things, and documentation, like you said, the first post-op day, I'm guilty of it myself, okay? I go on rounds the next morning, just look at all the patients and say, do this, and walk off. God knows what is written after that. God knows what my postgraduates, with due respect to them, what they've written. We never counter check. And believe me, when the case comes up in court, you will realize that everything you did was right, but it was not written. Okay, and that one thing will drown you. And I think at least before the patient goes from there, it is responsible. I think it's very, very sensible, and that meticulous component of 1 minute may save you 1 crore of rupees. So
I think regular training sessions, regular reviews on consent and documentation should be done at institutions and at clinics also.
So may I just add one point?
It is not the nurse's job or the paramedic's job to get the consent done. That the doctors must learn.
Sir, Mohan sir, just like you spoke about FOXI insurance for the hospitals as well as doctors in association with CoverU, where they can give us the lawyers or we can appoint the lawyers. The second thing what we have got through AOS is an out-of-court settlement also to a certain extent is supported in this. That's point one I wanted to make. As regards the consent part, you said take a lawyer's opinion. Now, if the society takes that opinion, say from you, we make a thing, give it to you. We have already made, AOS has made. Would it be?
Absolutely, sir. I think I or even my young colleagues here for some of the hospitals, and we make it a point to randomly pick up one file from their medical records department to find faults, even in not entering the medical registration numbers on the doctor's progress record. You can see so many faults. Fortunately, they have not gone to court.
Yeah. 99% of flaws are never picked up, but I think
on one form you find husband as Somnath, in the other form you find husband as Ramnath. The court says you not applied your mind, but it's not the doctor's job to do the investigation to find out who the husband is. But due diligence has to be made. How due diligence has to be made? You have to educate yourself. You have to involve a lawyer. Probably, see, it's becoming inevitable. My firm is called Medical Law Practitioners with a single L in between. It shows the inevitable association of medicine and law. Doctors are going to be with lawyers. It's inevitable.
Last question, both to Ellen and Dr. Rajasekhar. What do you think is an ideal quantum of personal insurance for an ophthalmologist? Means you should say, you shall not take an insurance below this quantum to be safe.
Yes, sir. For an individual, sir, I started with 5 lakhs. Now it is 2 crores.
Dr. Rajasekhar?
It's an important question. Depending on the load of the patients that a doctor is handling, if he is handling around 15-20 surgeries per month and maybe seeing 20-25 cases per day, OPD, he should have at least 2 crores of insurance. That's going to cost around 60 to 80,000 rupees, this thing. And you can take from multiple agencies like AOS as well as independent. But most important is to read the insurance document. When you take 2 crores, is it for one instance or is it for 5 instances or 4 instances? If it is at 4 instances, that means any one case can go up to 50 lakhs only. So, but you are eligible for 3 more instances. If it is taken as for one instance, then the entire 2 crores is for one instance. It's only 2 or 3 page document. It's extremely important to read that document and do that. And whatever this is not a cost. Actually, this is an investment and peace of mind. So if you are paying 80,000 rupees, see the number of patients you are seeing in the year, divide among each one of them and put it back to them, because it's for their safety, for your safety. So don't see it as an expense. Similarly, as Mohan was saying, it's extremely important to get the medical audit, the legal audit done for each firm. So they see whether all your registrations are done, all compliances are there in place or not, and then at the same time a random check of the. And if your workload is more, it's better to have one of the legal experts as a retainer, because they'll be a friend one phone call away, and that's peace of mind. Any brown cover, you don't have to worry. So in India, anybody can send you a brown cover, anybody can send you a legal notice without even having to have any ground for sending that. They go scot-free. So that's the kind of vulnerability we are in our profession. And as doctors, we tend to read in between lines and try to read the language of the legal notice and get bothered about it. Don't bother too much. Any legal notice will have all kinds of nonsense sentences, nonsense words, everything. That's how it is drafted. So it doesn't mean that you are so and so. So it's just take the help of professionals and go over it.
Simply means that when a lawyer sends you something, he wants to bully you. Okay. Sorry, no. Last word from any of the younger lawyers and then we close.
So, only one word that I have is consent form and clinical notes. They are very crucial because that can be asked by the patient, not by going to a lawyer. A written response saying, I need my medical records, will bound the doctors. So, consent form and clinical records are extremely important.
Is there a time frame within which a doctor is expected to give the records of the patient?
72 hours is what it says.
72 hours, and you have to give it all to the patient.
That has been
amended now 5 days.
Not bad. So,
no, but the amendment is yet to conceptualize is what I've been liberal view. Yeah.
Okay. Thank you, everyone. Question, yes.
One last question. It says corporate hospitals and all. Just a view from your team. A lot of us also do charity work, camp cases. If there is any mishap happens or there is a complication happening, and for some reason the surgery has not been successful, who or how would you be, let's say as a patient attender who is nothing to do with directly to the patient, can he send you a notice, and how would you respond in such cases? In camp cases, we do charity, we have like NPCP guidelines and all.
No consideration paid. Right. Now say suppose it's a botched up surgery in a camp and there is some unethical practices or hygiene is not maintained. Things like this, they go to the KMC. There's a larger public responsibility on KMC. See, I may not be directly related to the patient, but if I notice that a certain doctor has been conducting himself negligently or is indulged in misconduct or has violated the code of medical ethics, I don't have to have personal interest in that. If I bring it to the notice of the Karnataka Medical Council, the Karnataka Medical Council is duty bound to investigate on it because it affects the larger interest of the public, because that particular doctor, delinquent doctor against whom a complaint has been lodged, is not a danger to that particular patient alone. He is a danger to the society if he continues to practice unethical means or continues to perform negligently.
Mr. Mohan, in terms of this charity where you said since there's no consideration, my perception is that would apply if your totally or wholly charitable. Now, if you have 75% paying and do 25% charity, it does not apply.
Does not apply.
Okay.
See, if you are a doctor who is running a corporate hospital but is setting up a camp exclusively in village A or B and then doing charity there, I would be able to convince a court that was purely charity.
Okay.
This is my, I don't know, third, fifth, I don't know.
Doesn't matter. You keep coming and keep counting. Okay. And a big thank you for BS to give us this opportunity to be here. Thank you. Have a fantastic day and fantastic tomorrow as well. Thank you.
Thank you.